and I welcome witnesses for our unions panel. In a moment, I'll invite each of you to state your name and the capacity in which you appear before the committee. But first, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded in Hansard and attracts parliamentary privilege. For these hearings, the committee has asked that any opening statements be written and forwarded to the Secretariat prior to the hearing. These statements will be incorporated into the Hansard transcript and published as supplementary submissions for the witnesses involved. It will now involve for the fullest that will allow us for the fullest discussion to occur during the hearing today. If you haven't yet provided an opening statement that you would like to have incorporated into Hansard, please feel free to send it to the Secretariat after the hearing today, and we'll seek to do that. We'll now just go through introductions. Could you just state your name and the capacity in which you appear today? We'll start with the ACTU.
My name is Joseph Mitchell. I'm the Workers' Capital Lead at the Australian Council of Trade Unions.
Thank you. And the ETU?
Michael Wright, Acting National Secretary, and with me is Mr. Cam Humphreys, who is, I might hand over to Mr. Humphreys.
Thank you. Mr. Humphreys, if you could take yourself off mute and then just state your name and position for the Hansard record. Submissions for the witnesses involved. It will now involve for the fullest, that will allow us for the fullest. We've got a bit of feedback there. We'll go to other witnesses and we'll come back to you, Mr. Humphreys, when you've dealt with those technical issues. The MUA.
Paddy Crumlin, I'm the National Secretary of the Maritime Union of Australia and also the President of the International Transport Workers Federation, covering 20 million transport workers worldwide.
Thank you, Mr. Crumlin. And the ASU.
Thank you. My name's Troy Dunne. I'm an organiser in the energy sector for the United Services branch of the Australian Services Union. I'm based in New South Wales. However, the ASU nationally represents a significant cohort of members working in the energy sectors and water and sewage.
All right, thank you. And we'll just try again with Mr. Humphreys. I think you're on mute there, Mr. Humphreys. Okay, we might have to persist with your colleague for now, and if you're able to join us successfully, we'll welcome any evidence you have. I'm going to start the questioning and then I'll offer the call to other senators. And I did want to start with the ETU because I noticed your media release this morning about your appearance for the inquiry, and a couple of things in your media release caught my attention, particularly because it's a distinctive perspective before the committee. You've raised some concerns that other submitters have not addressed. We've had certainly many critical submissions, but there are particular concerns you raised. For example, in your media release, you state that apprentice electricians will be held to the same security standards of ASIO officers. What part of the bill requires an apprentice electrician to go through the same vetting process as an ASIO officer?
I think I understand what my colleague was referring to there, Mr. Paterson. First, might I say thank you to the committee for permitting us to appear today. So we've been engaging with the Department of Home Affairs around the rules that would be drafted under this bill should it proceed. And to date, we have had, and this is not necessarily criticism of the Department of Home Affairs, but the department isn't familiar with our industry, nor would you reasonably expect it to be. The issue we have, by way of example, is that they're requiring that the AUSTRAC, well, the draft rules that they've designed have said that everyone who provides access to assets would therefore need to go through the AUSTRAC regime. Now, that may or may not make sense in other industries, but in an industry where asset means power pole, and that you do need an access permit in order to work on that power pole, that means that the entirety of our workforce, all 40,000 workers in that industry, will perhaps wind up requiring to go through that AUSTRAC, that ASIO backgrounding, as we understand it, as well. And Mr. Humphreys is able to speak to this more broadly. We already have employers relying on this bill to seek to implement digital footprint tracing and really start to pry into the personal lives of our members. So that's where we see that analogy coming from. It's these rules, like I say, they may or may not be sensible in other industries, but it seems to be like a cookie cutter approach. In our direct experience, has what I imagine is unintended consequences and an unintended sweep of the capture.
Yeah, I mean, it certainly would be an unintended consequence if an apprentice electrician had to go through the federal government's positive vetting process that an ASIO officer does. I mean, that's a process that can take anywhere between 6 months and a year, and researches extensively all of the family and personal connections that an officer might have, their international travel, their prior employment. Are you suggesting that seriously apprentice electricians will have to get a PV security clearance to work?
So in our engagement with the Department of Home Affairs, we've been quite clear that we have a number of issues with the bill as it's presently drafted, but we've been seeking to engage with the rules drafting in good faith to, in the event that it does go through. And we're raising these concerns with them. And to be honest, the consultation approach adopted today has been very much an expectation that we sit and listen. I think there's been an electronic town hall where there was 200 odd attendees. There's been a separate consultation subsequently with us. We raise these concerns and we get nothing back.
Right.
Took the next step of trying to really gain attention to what we see as a genuine issue. And the utilities have no desire to be going through this. The apprentices obviously have no desire. The workforce doesn't want it, which is not to say that we don't already have stringent security checks in place in the industry.
Sure. And look, I mean, I see Senator Keneally's unmuted. She might want to make a contribution here.
It's more, Chair, it's an issue of the microphone. Mr. Wright cuts in and out, so I'm missing about it. I don't know if other panelists and committee members are in the same boat, but I'm only getting about every second word from him.
Yeah, no, it's certainly not perfect. Yeah, headphones and microphone.
It's very hard.
Minuses.
It's very hard to hear.
Thanks, Deputy Chair.
It's ironic that the ETU are having communication problems.
Oh, very unkind of you to point that out, Mr. Crumlin.
You see, it started already. You can already see the impact of this critical infrastructure bill already.
Okay, well, look, thank you for raising this issue, because it would obviously be absurd if apprentice electricians were subject to the same induction and security checks as an ASIO officer. I'm interested in your reflections on the consultation process, and I'll open this question more broadly to all the unions to reflect on this, because I've asked this question to a number of other witnesses as well, and they've actually been quite complimentary about the Department of Home Affairs consultation process. And I think it would be fair to say that's not always been the experience or the evidence of this committee. Sometimes there have been gripes and complaints about consultation, but the affected industries have been unusually complimentary. So could you, the ETU and any other witness who'd like to contribute here, go into a bit more detail about that consultation process? You don't feel that it's genuine, you don't feel that you're being listened to?
Perhaps, may I ask, am I more audible now?
Yes, that does sound a bit better.
Consultation, it's not so much perhaps the genuineness or otherwise, it's just the rules to the industry. Out again?
Yeah, it is not awesome connection there, I'm afraid. What I'll do is I'll offer other unions an ability to comment while you're working on your connection. It's possible that dialing in through the teleconference might be more reliable for the audio quality. But do any of the other unions wish to express a point of view on that consultation issue?
I might give a sort of global view of the movement's experience with consultation.
Please.
The union movement wasn't made aware that the exposure draft of the Critical Infrastructure Bill was available for submission when it was released by Home Affairs. And we only found out about this bill through expressions of employers seeking to get ready for compliance through this bill. We made submissions quite late to the Parliamentary Joint Committee and engaged with Home Affairs on its town hall style consultation process. However, we think that we probably would have been better served to engage earlier during co-design of the global rules so that we could set down principles by which positive security obligations were set. And in those participations in town halls are essentially useless. When you have a few hundred people on a call asked for their view, then the ability for you to substantively engage is pretty poor. We don't have experience that Home Affairs has requested the views of unions in specific sectors. either, other than the ETU. And we think it would be sort of fruitful for Home Affairs to be proactive about engaging with affected industries and their workers' representatives who don't have familiarity with the bill and are only coming to grips with its consequences now, particularly where we see about 4 million workers in these affected industries. If you go through the widest definition, we don't expect necessarily every worker to require a security check there. However, the evidence that the ETU has in that people with access to critical infrastructure will be required to undergo security assessments means that, you know, could be food and grocery workers are under the same framework in this shell legislation as workers in, you know, ports and maritime. And the proportionality of the risk assessment and the reasonableness of that hasn't been tested. And we'd be seeking greater work with Home Affairs to make sure that the rules that are designed, if they're designed, have basic principles in them that respect workers' rights to privacy, that, you know, quarantine information from workers, that have a formal appeal mechanism to ensure that they're reasonable. No union has expressed concern with the intent of the bill, that we do need to ensure that critical infrastructure is protected. But we are concerned that the implementation process at the moment hasn't included the voice of workers and doesn't have those basic guiding principles to ensure that security obligations are consistent and proportionate to the risk.
So just to clarify, Mr. Mitchell, on that consultation process, was it that you weren't aware of the public consultation process that was being run? I mean, the Home Affairs Department, as I understand it, announced it publicly late last year and invited submissions.
They didn't invite submissions from the ACTU, which would have been a good conduit to inviting submissions from the union movement.
Well, I think it was publicly announced. I don't think there was any restriction on submissions. I don't think
No, I'm not
they were turning away.
I'm not suggesting there are, but national security legislation isn't a common area that touches so many workers at once. And
Right.
the scope of this bill, we think, would have merited Home Affairs in being proactive and seeking the views of the union movement.
So you're saying that an open invitation for any interested party to submit is not sufficient, that the ACTU needs to be specifically invited to submit in order to take part?
Well, open invitations and submissions in legislation appear everywhere, right? So we have to be selective in terms of allocating resources. And if we were made aware that this bill at an early stage would have such a wide scope of impact amongst people's eligibility to work, then we would have promptly responded at the exposure draft stage. And, you know, we are engaging at the moment through Home Affairs consultation work, but we think that it would have merited coming in earlier and then giving us the opportunity to have deeper engagement going forward rather than coming in late. And we do feel as though we're coming in late. I mean, not being involved in industry co-design, for example, does feel as though, you know, we are getting allocated a small portion of Home Affairs attention than what we think would be better off in deeper engagement.
Okay. All right. I need to share the call with my colleagues. Senator Keneally, you're taking the call?
Yes, thank you, Chair. Thank you to the ACTU and the other unions for appearing today. If I can, I don't know if we have Mr. Wright back. Do we have him?
Hopefully you can hear me now, Senator.
Yes, I can. So did I understand you to be saying that you have examples of an employer or employers who are already relying on this legislation in terms of and telling their workforce they're going to need to undertake more rigorous security checks or even an expansive Oz check? Is that what your evidence was?
That's correct, Senator. I'll hand over to Mr. Humphreys in a sec to discuss his experience. But even as recently as last month, we had an employer relying on this bill as evidence in proceedings in connection with the union's application for a protected action ballot, that they were relying on this bill in opposition to the union's application. But Cam, if I can hand over to you, would you be able to tell the committee about the experience with Powerlink?
Certainly. How is my comms now, guys? Am I all clear? Thank you. Just because I missed doing it earlier, Cameron Humphreys, Senior Delegate for Powerlink for the ETU, and 31 years in the electrical supply industry in Queensland. Early this year, I was called to a meeting, and this was a sideline piece just to say it was coming into effect that a higher regime of security checks were to be enforced, and that they were to apply and in the way that it had been described, and the framework that was being set up in place by my employer was that if you had access to a site, then or to a drawing that affects that site, any of the technical data around a particular piece of that infrastructure, then you would be subject to these checks, which covers a large part of our workforce. Those checks were the high-level ASIO and AusCheck, and the digital footprint. It laid out a lot of what was going to be done, but it didn't have any information around those kind of protections that would apply to the worker should they have a dispute around any finding. The supplied examples of what they were going to get back involved things like drink driving, all manner of things that were unlikely to impact on someone's efforts or abilities to do their role, and it seemed to be that nearly all of us would have the ability through subjective analysis of our digital footprint to be classed as no longer fit for the role. One example that was given is if someone had shown signs of supporting, and this is why I believe there's a chance for overreach. It said, if someone's Facebook page had evidence of them being supportive of a drug culture, or perhaps liking a page around legalizing marijuana or something, then they may no longer be suitable to do high-risk tasks because under our policies, we have drug testing in place, which is random, but this would be an indication that this person has an interest in that culture, and potentially we would have to not allow them into that space because of a concern raised by digital footprint. So for me, that was concerning that, I believe if you've done a crime and you've done your time, and reform is what it is, some of these judgments that could be made without the employee having the opportunity to explain the context. And the unfortunate part was, I think, and this is as well, is that some of these people that be subjected to this are 30, 40-year veterans of the industry who have shown, they go out in the middle of the night in the dark to make sure the power stays on when we have natural disasters and the like. The idea that they'd go out there and deliberately harm the physical assets is just something like, it has never occurred. Can't point to an example anywhere in Queensland where this has taken place. Understand the cyber security part, but this personal level around physical assets, I just don't believe there's the evidence that there's an issue in the first place. And these checks seem to overreach to the point that they could be used for other purposes as well.
So if I'm understanding you correctly, Mr. Humphreys, you've got an example of one employer who's already advising their workforce that they are going to be conducting more rigorous or expansive security checks, possibly the AusCheck, possibly surveillance of their personal internet activity and the like, as a result of this legislation.
Correct. In that's there through the co-design. I guess that is that they have been involved with. They believe that in order for them to meet their obligations of the framework, this is the minimum they would need to do.
And are you able to tell us the name of that employer?
Well, I'm a senior delegate for Powerlink Queensland.
For Powerlink in Queensland, right? And because this is something I think the committee would want to follow up with the department as to whether or not the legislation really would have that type of effect, or if this is something that is an over enthusiastic or over aggressive interpretation of what the rules would require, bearing in mind that many of the submissions have made the point that in most of the sectors, the positive security applications have not yet been defined. They are being left to regulation. So I think this is really important evidence that you're putting before us that enables us to follow that up. I note as well the media reports today in relation to the potential for these security checks to be expanded into some kind of wholesale mass surveillance. You've raised concerns about how it might be expanded beyond the energy sector. Is that correct?
Well, the bill itself, I understand, was going to take into effect the 11 other industry sectors, but what it had also applied to visitors to those sites. Our workforce representatives that sit outside of the company but are part of the broader union movement, our organisers are all going to be subject to these raft of security checks in order to even do a right of entry to represent workers when there's safety or other issues that may require their presence on site. And it without, from what I've seen, without the background to the arbitration or disputes process, I could be deemed as unfit by my employer, and that may limit my ability to work in any other industry attached to this legislation. Just on the fact, that I'm an electrician, I can no longer work in the ESI, and I try to work for a contractor and go into a data centre to do work where electricians will be working. It effectively may see me blacklisted out of my trade.
Yep. Okay.
Senator, if I may, this touches on one of our key concerns. That we originally became concerned around this bill because of the issue of confidentiality and there's just absence of quarantining personal information from the employer, from a person's employer, which has implications for the spent convictions and the like. That data will just forever be retained. But it also goes to the fact that where an employer does adopt a maximalist approach in designing their plans to meet the rules, there's no capacity for the workforce or their representatives to challenge that plan, to say that this plan is more than is required. And there's nothing in the bill that implies or suggests that the department or whoever the regulator ultimately is would reject a plan because it went too far.
Yeah, and that's all actually quite useful as well in terms of thinking what the committee might want to contemplate in terms of guidelines or rules or recommendations to the legislation. I might hear, Mr. Wright, while I've got you speaking, ask you about, you mentioned earlier, in addition to the PowerLink example that we've now had, in terms of expanding security checks or surveillance across a workforce, you also mentioned an example of an employer using this bill as a reason to shorten a negotiation period. Is that what you said? If you could just return to that example.
Thank you, Senator. So, and just for the benefit of the committee, PowerLink, who Mr. Humphreys was referring to, is the responsible for electricity transmission through all of Queensland. It's a publicly owned entity up there. The other utility I was referring to is Endeavour Energy, which is responsible for electricity from Greater Western Sydney south to the Illawarra. In our protected action ballot application before the Fair Work Commission last month, the Endeavour Energy relied on the existence of this bill as evidence for why extended notice periods should be given for protected action, and why the Commission should consider whether or not the action should be granted at all, as I understand it. Now, and that was put into evidence by Endeavour. It's more than happy to share that material should the committee so wish. But what we see there is that Endeavour's already relying on this for tangential purposes to what perhaps the aim of the legislation is. And I should also take the opportunity to say that Transgrid, which is responsible for the transmission of electricity through New South Wales and the ACT, and also has some other functions, we are advised already implemented a system in anticipation of this bill passing. So what our members are already facing is the real world effects of this bill as if it were already enacted, which is.
And what has Transgrid done? You say they've implemented a system in anticipation of the bill.
I don't want to go too far on this point, Senator, because we are still trying to nail down the precise details, but it is certainly criminal background checks, and it is also some degree of tracking of online social media and the like.
Can I ask Mr. Wright, if you're able to, when you have some additional information, or what if you could supply some information to the committee about Transgrid specifically, and also the information that you just flagged in terms of Endeavour Energy and the protected application before the Fair Work Commission, their citation of this bill, that would be useful if you could supply that to the committee.
I can assist there a little bit, Senator, if it's of any use.
Oh, thanks, Troy. Yeah, go ahead, Mr. Dunne.
Yeah, it's me, Troy. So thank you, everybody. I appreciate the opportunity to appear before this committee. I will admit to nerves, so if I start to stammer, I do apologise in advance. However, I do firstly want to make some comments in support of Mr. Humphreys and Mr. Wright with regards to the potential for disqualification, if you will, from your ability to perform your role as an existing employee, or if you were a prospective employee. Indeed, and the same applies in New South Wales. Mr. Humphreys touched on the relative tenure of employees at Powerlink. The same can be said here in New South Wales, and that goes from end to end, to wit, generation, transmission and distributors. The tenure of employees in these organisations is significant. So that they find themselves potentially in a position to being subjected to such a level of scrutiny is of a concern to them. With regards to Transgrid, the interested unions being the ETU, the United Services branch of the ASU, and Professionals Australia, or PESMA, raised significant concerns last year with regards to the engagement of a agency called My Verification Services. This represented a highly invasive system that didn't require the consent. For all intents and purposes it did, but in practice it didn't operate, in that we had a significant amount of members receiving phone calls at home on their private home numbers and mobile numbers with regards to complying with the engagement of My Verification Services. And indeed, I'm in receipt of an email from a couple of weeks ago, whereby other employees are being subject, if I may try and read and talk at the same time. It would appear they've engaged a service with the acronym MVSI to carry out similar checks. And backing up what Mr. Wright was saying with regards to Transgrid, furthermore, Transgrid have openly admitted that there is no appetite to objectively apply the findings or outcomes of, if you will, of such checks against the roles being performed by cohorts within the business, i.e. your administrative officer is subject to the same level of scrutiny as a frontline operator. So these are raised significant concerns in that regard.
Thank you. Yeah, thank you, Mr. Dunne. That's actually quite helpful for the committee to understand what some of the actual on the ground practical things that are happening. Did you say people were getting phone calls at home at night? And yes. Your understanding that was related to Transgrid?
Yes, that related to Transgrid. The phone calls weren't from Transgrid. The phone calls were coming from the provider, if you will, in the they being called My Verification Services.
Mm-hmm. All right, thank you. That's very helpful. Now, if I can also ask, so I did also ask then Mr. Wright if it's possible to supply us with that information regarding Endeavour Energy and the protected action application, as well as any other addition of information you have about Transgrid. If you could take that on notice, I'd be really grateful. I also had a question for the MUA. I note that your supplemental submission your submission, I should say, goes quite specifically to the issue that the bill omits reference to ships and sea freight corridors as critical freight infrastructure, that only road and rail is mentioned, and that ships as carriers of oil are not captured in the bill's definition of critical liquid fuel asset or part of the distribution and supply for food and grocery sector. What is your recommendation to the committee? What is your concern there, and what is your recommendation to the committee in terms of how we might, how the bill might be improved? Did we lose Mr. Crumlin?
It's a sort of a faux pas of the modern world, isn't it? So even the bill extended the definition of infrastructure assets by another 22 and into areas such as critical electricity assets, critical food and grocery assets, freight infrastructure, those types of things, gas assets, liquid fuel. Didn't mention shipping, and there's no mention to shipping that's embedded in all of the issues that this critical infrastructure bill is seeking to address. Now, there's 6,000 ships visit Australia every day. We're the 4th largest user of ships in the world. Most of them are registered in places like Panama and, the Caribbean. And those types of places, there's a form of tax evasion and a sidestep regulation. So many of them operate full-time on the Australian coast under the current laissez-faire application of permits for ships. And yet they don't meet the same rigorous standards when we have concerns about privacy and some of the other things that the ETU have identified and the ACTU identified. But generally speaking, the maritime security identification case is very rigorous. There's a whole process of a security assessment by ASIO. There's many layers into it, and we've been managing this for quite a long period of time, as they have been in aviation. And there are concerns about overstepping the mark and, I guess, moving things into an area where privacy are impinged in those areas. The reality is, for every other seafarer that is servicing all of the critical infrastructure, they're only required to have what they call a maritime crew visa that you pick up in a couple of days. All that's required is basically an ID, a cursory check. There's no ability to go to the Ukraine, not the centre of governance in the world, and or regulatory overview, to go and check on who those people are, notwithstanding the fact they might be moving ammonium nitrate around the place. A lot of ammonium nitrate. We saw what it did in Beirut. They may be, you know, we saw the live ship went down with the loss of 40, including 2 Australian vets. And it goes on and on. You know, I don't want to go through the submission. We've identified the enormous risk in this area, our almost total reliance on it, the fact that it's deregulated. Under COVID, some of these seafarers have been there for 2 years because they can't get off. We won't let them off in case they've got COVID, and yet we don't know who they are in regards of any background check. So I guess what goes to the core of our concerns is the uneven application. And in fact, I was surprised. I've made submissions to Homeland Security in the US and in Canada in my role as ITF president. That, you know, gets back to this thing why there wasn't a sort of a workshop or a forensic approach to these areas of risk so that we could sit down and work out a template for mitigating it. And so it's like an extension of a type of bureaucratic negligence, I suppose. That we're just focusing on certain areas, saying, well, look, okay, we're doing the job, maybe with overreach, which is the ACTU's concern, but in other areas, we're not even on the board and don't even understand it. For example, a lot of the shipping, much of the shipping is controlled by China because they're our main trading partners. If they decide that they don't want to let those ships into China because they don't like what we're doing down here, for example, they just keep them at anchor. They control the shipping. A lot in the Act, it doesn't even identify who owns these ships. Many of them are owned by $2 companies in Luxembourg and Geneva and the Caribbean. So there's no thoroughness, a forensic thoroughness. There's not even identification, senators and members of the real critical issues in this. And it's sort of sandpapered, it's not sandpapered, it's wallpapered over by saying, well, look, there's all of these big concerns about Australia and island nation. And, you know, we need to address this as a matter of urgency. So there's this enormous gap in the middle. Most of our submission goes to that. I mean, they tried to drop off a ton of cocaine in Botany Bay with a bloke who came from Tarrant Point that went to pick it up. That was only 6 months ago. Like, that's not a security infrastructure risk, you know, that there's people aboard the ship. And the ship was a MIC, Mediterranean, one of the biggest ship owners in the world, foreign ship owners in the world. And that's the type of thing that's going on a regular basis. They're only the bits we know. And yet we're not really applying ourselves. Why? Because in the too tough basket, whereas an Australian wharfie and a seafarer who goes down there is pretty well got to jump through 1,000 hoops. You know, the whole process of criteria continues to be revisited, more rigorous, and that's sort of, you know, that's a legitimate area for discussion. I'm not going to. And here's this other whole area that just does not feature in any specificity other than to identify every one of those industries that almost overwhelmingly rely on those ships and those crews to deliver the essential economic, because it is essential infrastructure. That's the reality. So again, don't want to go on. Good, thank you for the opportunity to speak. Good to see some of my people that like to comment on the MUA. Quite widely, actually, to be able to have a level of conversation one-on-one, and we look forward to further around this. So thank you for the question.
Yeah, thank you, Mr. Crumlin. I think particularly the point we heard from an earlier submitter from the US, Mr. Krebs, where he talked about their approach was to ask what would affect the continuity of the economy. And also we heard from Vice Marshal Blackburn on a similar argument about affecting the continuity of the economy, but also and supply of things like fuel, and in the case in your submission, food and grocery. It's undeniable as an island nation, the continuity of our economy relies on shipping. Your submission does recommend that this act should be applied to shipping to provide greater transparency around ownership. You also recommend that it refer to the availability of Australian ships to provide alternative transport. Just for some clarity for understanding, you reflect, Vice Marshal Blackburn gave us some information regarding the number of Australian flagged vessels that are actually available for international shipping with some comparisons to international counterparts. Are you able to just say a little bit more about that? You talked about how a lot of these ships most of these ships are foreign owned, and some of them are owned, or flagged through China. Can you just speak a bit more about that?
Well, the reality is that Australian ships pay tax. They're regulated, some would say over-regulated. That's the TU and the ACTU's argument. It's very expensive to do all these background checks to make sure that they meet all of those standards. So there's all these layers of cost in Australian shipping. This is servicing Australian domestic transport infrastructure, and not really, there's a larger issue in external. As we know, I've already mentioned China. I mean, if there was a little bit more forensic work when they sold the port of Darwin, they might have worked out that, the Chinese military got their oar in there. So the reality is in shipping, of course, they're dominant, and we don't know, and we're not asking. But in this specific area of Australian shipping, we're expected to clear an enormous hurdle that no one else is expected to clear. And we're competing against them in a domestic transport chain, and so is rail and road, and they're having to meet, if they're covered by, the critical infrastructure, they've got to meet all of these standards where the competition does not. So the reality is, we're losing control of those supply chains in essential things like oil, the supply of oil. We've only got 1 or 2 refineries left, so we bring it down from Singapore or Indonesia, and they're very parlous and high-risk areas, and we've got no control over that. And we've got no ability to engage in it in a constructive fashion because we've been in denial about the importance of shipping as critical infrastructure for so long, even to the extent of not even mentioning it. Like, this is Freudian, isn't it? This is a sort of a Freudian overview of policy making, that here is this critical area that everybody knows in the world, and yet we don't mention it in our security bill. So again, the ultimate thing is, with that type of policy negligence, of course, that sector of the industry of critical infrastructure, supply chain infrastructure, is withering, and we're not doing anything to mitigate the increasing risk. If it's not there, it's not controlled, it's not regulated. So we're going to have these really high faluting requirements for maritime workers, but no ships to put them on now. There's a public interest irony in that, isn't there? And again, we're just drawing to the attention in our humble way, that we've been saying it for a long time, that it's critical for this committee to identify, if they're serious about doing a gap analysis on this, and we want bipartisan political support in this area. We're not banging a political drum. We want to work with you, but to work with it, you've got to identify the risk in the first instances, so that we can go able to identify and clothe it with more detail. And we've got plenty of it, Senator.
Okay, great. Look, thank you so much for that. I just have one last question, and really possibly I'll put it to the ACTU on behalf of the of all the panelists. If I take it from the submissions that there is that the ACTU and the panelists here support the need for a bill like this one, that the issues you've raised really go to the implementation and impact on workers, and around clarity around guidelines and rules. Is that a correct assumption of the view? You're not opposed to the legislation. I think it's important we have some clarity on the record in that regard.
So we're not opposed to legislation like this, which ensures a framework for addressing systemic risks to critical infrastructure. However, the legislation as drafted lacks some clear principles for its implementation. So as the MUA ETU, and the USU pointed out today, there's a lack of clear definitions over just who it applies to, and both being vague about its references to shipping and then perhaps being deemed to apply to construction of and maintenance of, or even supplying to critical infrastructure assets through these responsible entities' responsibilities for their supply chains. There's also a worrying lack of proportionality and limiting of the ability of employers to access information and the proportionality of each employee's actual risk to an entity or an asset. We'd seek the committee's work to improve the bill to make sure that there are principles underlying these rules and there are abilities for workers and employers and key stakeholders to raise grievances either with the rules as they're written, challenge the implementation of rules with employers or with infrastructure assets to make sure that they're applied properly, and also challenge the scope of the bill to ensure that it's achieving its objective. We think that this sort of work would be better done with deeper and more regular consultation with the union movement. We know that the PJCIS is doing a really good job of consulting with each industry, dedicating significant resources to telecommunications, later in the day technology. We think that 1 hour with the entirety of the union movement is not sufficient, and we'd welcome the opportunity to come back again and give our perspectives on an industry by industry basis. Workers in the higher education sector might have some more to say, as with healthcare workers, onto this, and we'd be glad to work with you to achieve that, to make sure that we've got a fulsome perspective.
Great, thank you, Mr. Mitchell. Thank you, Chair. I'll conclude my questioning there.
Thanks, Senator Keneally. And of course, would have welcomed a submission from the NTEU, but we didn't receive one. We've prioritised the unions who've engaged most closely with the committee with submissions or other correspondence. Mr. Wilson.
Thank you, Chair. I've welcomed the contribution from the witnesses here and their concerns about over-regulation and the impact it has on competition, and it's certainly consistent with many of the other issues we deal with, but I'll leave that to one side. The question I am interested in is, have any of you done an assessment on whether there will be an obligation or a need for additional training for your workforce to be compliant with the obligations being proposed in the legislation?
I can comment on that, perhaps, Joe, Mr. Paterson. So, well, that's been one of our submissions. There's merit-based selection in the waterfront, certainly, and there's very layered HR processes. A lot of that is critically designed because of the nature of the MSIC card. And we think that, and I guess part of our argument is that there is such an overlay in these genuinely intense security infrastructure areas that there is the idea of having a separate framework that demands individuals to meet a much higher standard perhaps doesn't reflect the relatively low risk of that individual. And that, yes, there has to be training, but it should be done in partnership, obviously, with the employers and by extension, the employer representatives and the employees themselves, to make sure that you get the balance just right, so that you are identifying sort of high-risk behaviour, where it may be, identifying the components of the bill when it's finalised and it passes, and be able to drive that in. And I think that's one of the reasons that the ACTU, and certainly we are, we've got a good relationship with Steve Dawes, might come to surprise you in this area and in many other areas, and ship owners, so that we can sit down and distill the essence of what's required behaviourally or culturally, and also make them understand the reasons behind it and the mitigating things. In fact, part of this is an appeal mechanism. What if someone has been targeted unfairly? And that's part of an education and training program too, that you've got rights in this process. So again, yes, that's a long answer. The short answer is I think that we need to integrate. That's why it needs to be a bipartisan approach. we need to integrate that training to have a thorough and transparent understanding of the intent of the Act and its applications and responsibilities therein. So yes, from our perspective, in a balanced way.
Thank you, Mr.
If I may,
Crumlin.
Chair.
Yes, just one second. Mr. Wilson's screen has frozen, but don't worry, I'm sure he'll eagerly look back on that evidence at Hansard. And in the meantime, if other witnesses want to contribute on this question, please do.
You might be thinking about superannuation.
No doubt.
If I may, Chair, the experience of the ETU to date is that employers have not flagged any additional training requirements. There will be the HR departments will need to be expanded, and as in the case of Transgrid, they'll need to engage external contractors, which all has a considerable compliance cost. From the union perspective, what we will necessarily have to do is train our members on social media. If it's going to be the case, as Powerlink has flagged, that a red flag would go up if an employee liked the hemp party on Facebook, or if they tweeted in support. Now, I'm not suggesting that the rules made by the regulator are going to say that, but if that's what the plan that the employer implements is, then we are going to have training for our members, which will naturally have a chilling effect on free speech, in how to, curb their ability to speak in a public space.
Thank you for raising that, Mr. Wright, and it definitely would be a concern to the committee, and I'm sure the Parliament, if legitimate political activism of workers was being singled out by employers in the pursuit of unrelated national security goals. I cannot see how a worker liking a hemp page marijuana decriminalisation campaign would relate to their ability to do their job safely. Are there any other contributions on that question from Mr. Wilson?
Yeah, if I may.
Please.
I think there's real uncertainty here because most of the rules for most of the industries have not been drafted, which makes it quite difficult to determine what the obligations on employees and workers and employers will be when it comes to training to comply with this legislation. That they are so vague at the moment. Legislation as a shell doesn't restrict it to go in any certain way. It makes it difficult to determine where each industry will end up. And so it does limit our ability to give a proper answer about whether or not there will be additional costs for employers or whether workers will need to seek training out of their own pocket to work at these sites.
Yeah, thank you, Mr. Mitchell. That's certainly been consistent feedback from a number of witnesses before the inquiry, that the uncertainty of those yet to be determined rules. Just in Mr. Wilson's absence, do any other committee members have questions? We just have a couple of minutes left. Dr. Ali, do you have any questions? No. Okay, thank you. All right, if there's no other colleagues have any questions, I'll just provide a last opportunity.
Scheduled to be disconnected automatically.
Okay. Well, can I thank you very much for your engagement with the committee, for your submissions and your appearance before the committee today. You have provided a valuable perspective and we're grateful for it. If you've taken any questions on notice, we'd like to have them back by 4 p.m. on Friday, the 30th of July, so we can complete our work. And as per usual, you'll be given a draft transcript of these proceedings in case you'd like to suggest any corrections to potential transcription errors. But otherwise, colleagues, the committee will now suspend and will resume at 1 p.m. with our next witnesses.